Have a seat. We're back on the record. All counsel present, defendants present. The jury is not. I've been handed a written stipulation signed by Mr. Eisenhower from Celedonio. It reads, the parties stipulate and agree that there are no disciplinary records from the Palm Beach County Jail for Eriese Tisdale from April 2009 to August 2010. All right. State and defense are agreeing that I read this to the jury when they come in?
Yes, sir. Yes, sir.
Okay. You want me to read it to them when they come in now?
Yes,
You can
sir.
see all of them, but okay. Is defense ready to proceed?
Yes, sir.
State ready to proceed?
Yes, Judge.
Bring the jury in, please.
All right, ladies and gentlemen.
Just read this. Is it too heavy? A little bit. Is that it? Okay, that's fine. Okay, thank you all for bearing with us. I think I can see everybody. Members of the jury, the parties stipulate and agree that there are no disciplinary records from the Palm Beach County Jail for Eriese Tisdale from April 2009 to August 2010. Defense call our next witness, please.
Defense would call Dr. Mark Cunningham.
Doctor. Thank you, doctor, for bearing with us. Come on right up here, and one of these nice folks will place you under oath. Right over here, sir.
Raise your right hand.
Do you swear upon the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Just watch stepping in, sir.
Good morning, Dr. Cunningham.
Good morning.
Please go ahead and state your full name and your title.
Mark Douglas Cunningham. I'm a clinical and forensic psychologist in private practice and also an independent research scientist.
Okay, and can you briefly explain to us your educational background?
Yes, ma'am. I received my undergraduate degree from Abilene Christian College with majors in psychology and in mass communications. That degree was with high honors. I was graduated magna cum laude. I then attended graduate school at Oklahoma State University and received both my master's and doctorate degrees from Oklahoma State University in clinical psychology. That was a doctoral training program that was accredited by the American Psychological Association as a doctoral training site. I then did a one-year clinical psychology internship at the National Naval Medical Center in Bethesda, Maryland, where I was an active duty naval officer and also clinical psychology intern. I was subsequently assigned to the Naval Submarine Medical Center in Groton, New London, Connecticut, which at that time was the primary submarine facility on the Atlantic coast, and was stationed there for 3.5 years, where I was an active duty naval officer and also a clinical psychologist. While there, I did 2 years of part-time postdoctoral study at the Yale University School of Medicine in a program that was sponsored by the National Institutes of Mental Health. I left the Navy and took a full-time academic position at a small private university back in West Texas. And did that for a couple of years while I established my practice. Since that time, I have actively participated in clinical clinical continuing education and also in forensic-related continuing education.
Okay. And how many years have you worked in the field that you're in now?
Well, I received my my doctorate degree in 1978, so that would be 37 years ago.
Just a second. Can you tell us any of the certifications you have?
Oh, yes, ma'am. I'm board certified in clinical psychology by the American Board of Professional Psychology. That's the board certification organization that's recognized by the American Psychological Association. Clinical psychology is the evaluation and treatment of psychological disorders. It's what you'd expect a psychologist to do in terms of interviewing, evaluating, psychological testing, counseling and psychotherapy services, that sort of thing. I'm also board certified in forensic psychology by the American Board of Professional Psychology. Forensic psychology is the application of psychological research and techniques to legal issues. It's any way that psychology as a science can be helpful to some issue before the court, all the way from evaluating of parenting capabilities in child custody cases, psychological injuries in civil cases, or in criminal cases, things like competency to stand trial, or a mental state at time of offense, or sentencing considerations such as are being heard today.
Okay, now you mentioned scientific in your description of yourself.
Yes, ma'am.
What are your qualifications?
Well, I was trained as a scientist. That's what a PhD is about. It's not only preparation in a clinical sense, but it's also training you in research and scientific inquiry. During the last 17 years, I've been actively involved in scholarly publishing and in doing empirical or basic level research. My primary area of research is on rates and correlates of violence in prison. That's a fancy way of saying how often does violence of varying severities occur in prison, and what factors are associated with a greater or lesser likelihood of that. And those studies range anywhere from some of them might involve, 100 or 120 capital offenders who are being tracked in prison. At the other end of that continuum, in terms of the number of subjects involved, there's a study that we have that looked at all 51,000 inmates in the Florida Department of Corrections. And so these range, depending on the size of the sample that's available. They may range from a smaller group that's being tracked and followed to 10,000, 20,000, 50,000 inmates.
Okay, and what is your current professional practice?
Well, I'm a clinical and forensic psychologist in private practice, and that's the overwhelming source of my income. And then the work that I do in terms of research is largely without direct financial compensation. I mean, there are many rewards from it. It's very satisfying to do. It's exciting to see something published. It's part of my identity as a scientist and professional. But it's not as if I'm paid for that publication, except for a few $100s of royalties that I get every year from a textbook that I published about capital sentencing. It was published by Oxford University Press that I authored.
And are you licensed in the state of Florida?
Yes, ma'am, I am, as well as about 19 other states.
Okay. And as part of your profession, do you testify in court?
Yes, ma'am.
And have you been published?
Well, yes, ma'am, I have. As I described, there is a text that I authored that was published by Oxford University Press that is entitled Evaluation for Capital Sentencing. This is one of a series of about 19 texts that are designed to describe best practices in different types of evaluations that come into the courtroom. And so there is a volume that's on best practices in child custody evaluations, best practices in evaluations of competency to stand trial. And I was asked to author the volume on best practices for evaluations that occur in this context, evaluations for capital sentencing. I was also the guest editor of the Journal of Psychiatry and Law on a special issue that was examining research and perspectives on capital sentencing. Then I've authored about, let me just look at my curriculum vitae. This is a fancy word for a resume. 1, 2, 3, 4, 5, 6, 7, 8. 10 chapters in edited textbooks that I have authored or co-authored. And then about 35 approximately papers that I've authored or co-authored that have appeared in peer-reviewed scientific journals. Peer-reviewed journals are the primary way that scientists exchange information with each other. And the way that works is that either the research in a given area is critically integrated and analyzed in what's called a literature review, so that other scholars or professionals have a single place they can go to get their arms around a whole body of research instead of having to go out and try to read and make sense of every publication in that area. And so some of my papers are literature reviews. Other times, the paper that goes to the scientific journal is one that involves original research, where data are gathered on a given question or in a certain population and statistically analyzed and written up. And so either way, whether it's a literature review or an original piece of research, it's sent to the scientific journal. The editor of the journal is a recognized scientist, and he evaluates it for its scholarly merit and identifies several individuals who are known to have expertise, several other scientists who have known expertise in the area that paper is written in. And he sends it to them, and they review it for its scholarly merit, whether it makes an important contribution to the field, whether the literature that's described accurately accounts for what's known up to this time, for whether the methodology is sound and the statistical analysis is accurate, and whether the conclusions that are described in fact flow from those results. Only about 15%, 10 to 15% of the papers that are submitted to leading scientific journals in the forensic psychology arena or criminology arena, only about 15% pass that quality control screen and are accepted for publication. And so in other words, this has gone through some quality control screen, and often the reviewers have suggestions for how to improve the quality of the article, and so it's rewritten and then resubmitted for review. And so there are about 35 or so scientific papers that I've authored or co-authored that have gone through that peer-reviewed process and then are published in leading forensic psychology journals, professional psychology journals, criminology journals.
Okay, and do you use that scientific aspect of your credentials in your practice?
Yes, ma'am, I do.
And in what way do you do that?
Well, I'll be testifying about that today, as I would look, for example, at the likelihood that Eriese Tisdale will adjust to prison without serious violence during a life term, if that's what he's sentenced to. Then I'm going to bring to bear research that my colleagues and I have engaged in. My colleagues and I have done most of the large-scale research on rates and correlates of violence in prison, and almost all of the research that tracks the behavior of capital offenders in prison. Those are people that were sentenced to death and then got relief from that sentence and are in the general prison population, or at their trials were sentenced to life without parole instead of death, and we're then tracking them in prison. Based on those studies, the factors that I will look at that raise or lower Eriese Tisdale's likelihood of violence in prison are directly based on the research that examines behavior of capital offenders in prison and other inmates, and what correlates, what factors raise or lower that risk. As I identify what's the likelihood, that's based on what's the rate of violence in prison among similarly described individuals. It's the same principle that a doctor uses in giving prognosis. Or even you go into the doctor with a strep throat and he prescribes an antibiotic. Well, that's based on group data of people who had this sort of infection, responded with what frequency to what antibiotic. And so his prescription of that is based on his knowledge of that group data and the rates of response that others have to that treatment. And so we're really talking about that same sort of process in this arena as well.
Okay, and how many years have you actually been testifying in court in reference to this type of topic?
Since 1995, so that's about 20 years now. My publications don't go that far back. Originally, that was based on the research that others had done in this arena. But as our research group has done more and more study, the data that we've published is both of larger scale, better designed, and more recent.
Okay, and approximately how many cases have you actually testified in as an expert?
I can't give you a total as an expert. It is well over 300. I've testified in over 200 capital cases. That hasn't always been about violence risk assessment. Sometimes it's about developmental factors. But over 200 cases in total.
Okay, and have you prepared the slide presentation to assist you in, to illustrate your testimony here today?
Yes, ma'am, I have.
And would that help with the jury in listening to your research and assessment of Eriese Tisdale?
Oh, yes, ma'am. When you look at statistics, your eyes tend to blur, and so yeah, it's helpful to look at charts and graphs and that kind of thing.
Okay, and did you have, you were hired by me?
I was retained by the defense. That's correct.
Okay, and did you meet Eriese Tisdale?
Yes, ma'am, I did.
When did that occur?
For purposes of this assessment, I interviewed him on May the 29th of this year, and I interviewed him for about 85 minutes.
Okay. Okay, and with the information that you gathered from Eriese in the interview, how did someone from my office or did myself, did somebody introduce you to Eriese?
Yes, ma'am, that's correct.
And how were you introduced?
I was introduced as an expert who had been retained by the defense.
Okay, and did they give Eriese any instructions in front of you?
To be candid in his responses.
Okay. And how did you describe yourself and what you were there to talk to Eriese about?
Oh, yes, ma'am, I have a standard spiel. I'm Dr. Mark Cunningham. I'm a clinical and forensic psychologist. I've been retained as an agent of your attorneys. Now, that doesn't mean they can tell me what my findings or conclusions will be, but it means whatever I find out belongs to them. I cannot be called as a witness against you by the state. I can only be called by the defense if they think it's going to help. If they thought for any reason that my findings would not be helpful to you, they would stay a secret with the attorneys. If they think they will be helpful, then they will release my report in an attempt to get the death penalty taken off the table, or because it's required as a disclosure before my testimony, or I'll be called to testify at a sentencing hearing. Once that happens, once I'm put in play, then anything I've learned from anybody I can be asked about. So it either all stays a secret or it potentially all comes in, but your attorneys will be in charge of that. And I would have gone on to say, I've been retained in this case to evaluate a very narrow issue, and that is your likelihood of serious violence in prison. because the factors that are predictive of violence in prison are relatively few, this interview will not be as wide-ranging as it would be if I was evaluating you in terms of your developmental history or other issues.
Okay. It's going to get a little different. You guys by yourself?
Maybe just slightly farther back. That's good.
Doctor, are you more comfortable standing or sitting?
I'm fine here, thank
Do
you.
you have the clicker to assist?
I do have the clicker, thank you.
Okay. Did you have an opportunity to get an individualized appraisal of your
Yes, ma'am, primarily based on the records that were provided to me, but then supplemented by my interview of him.
Okay. And so there are specific records that you would want to review prior to making your assessment for prison for Eriese, right?
That's correct.
And you did so.
Yes, ma'am. Those are things like educational records to the extent they show how far he went in school, employment records, jail disciplinary records, records that would demonstrate his age, visitation records from the jail that would show who's coming to see him, how often, records of prior times that he's been in custody. So a relatively small range of the sorts of records that are associated with factors that are predictive.
Okay. Now, what about the actual crime itself, and what he's been convicted of? How does that come into play as far as violence?
Well, for purposes of my work, as I'm doing an assessment, I assume that the defendant is guilty as charged. Now, I don't have any independent knowledge of that, but at the point that I would come and testify, he or she would have been convicted of a death-eligible charge. That's what would then result in my testimony. So for my purposes, I'm assuming that. In terms of what's predictive of violence in prison, the only feature of a capital offense that's been demonstrated to be predictive of violence in prison is if the capital offense is committed in conjunction with a robbery or burglary. And if that's present, then that modestly increases the risk of violence in prison. But otherwise, whether it is the murder of a law enforcement officer or a murder in the process of a sexual offense, or the killing of multiple individuals, those are features that are disturbing but are not predictive of violence in prison.
Okay. Let's get started. What kind of factors do you have to look at?
Well, there are a number of factors that I had identified in this case that point to Eriese Tisdale having a low likelihood of serious violence in prison. And those factors, again, based on research data, are that he would be 28 years of age at entrance into the Florida Department of Corrections on a life sentence, if that's what the jury chooses to sentence him to, that he's only had minor disciplinary infractions in over 2 years of jail custody, that he does not have a pattern of violence in prior jail custody. His education is a high school diploma and also an associate's degree. He has continued contact with community members through visitation and phone. He has been convicted of a capital murder. He would be serving a life without parole sentence, and he would be an inmate in the Florida Department of Corrections. Those are all factors associated with a low likelihood of violence, of serious violence in prison.
Okay, now, before we go into detail about each of those factors that you would use to make your assessment, how is the risk of violence broken down?
Well, the overarching question is, will there be violence? But actually that's made up of 4 sub-questions, 4 corollary questions. The first is, what's the probability? This is not a yes or no determination. Yes, he will, no, he won't. Instead, it's what's the relative likelihood. Either what's the relative likelihood as an absolute matter, 1 out of 100, 1 out of 1,000, or as a comparative matter, how would his risk compare to other individuals in prison or other capital offenders? And so the first issue is what's the probability? Because you can't say about anybody there is no likelihood that somebody's going to be violent, of anybody here in the courtroom. And you also can't reliably say 100% likely this person will do this. Absolutely. And so instead we're identifying what's the probability of what form of violence. Now that's a critically important consideration because the more severe the violence is, the dramatically less likely it is to occur. So for example, if the question is, what's the likelihood that he would shove another inmate during a life term in prison? Well, that likelihood is almost 100%. He's going to have to show a willingness to stand up for himself in order to prevent further victimization. On the other hand, if the question is, what's the likelihood that he would kill a corrections officer? Well, that's an event that happens about 1 time in state prisons in the whole United States each year. That incidence is about 1 per million inmates per year. And so that's infinitesimally unlikely. And so if you want to talk about what's the likelihood, you have to specify what severity of violence are we talking about. At what time period, that means at what age. At age 28 as he sits today, or 10 years from now, 20 years from now, 30 years from now. Because the risk is not the same at 28 as it is at 58. And finally, in what context? Are we talking about him being in the general prison population, where he's double-celled, goes out on the yard with other inmates, is involved in work roles, that kind of thing? Or are we talking about him being in solitary confinement, or what we call supermaximum confinement, where he would be in a cell by himself, where he is shackled before the cell door is open, backs up to the food slot, shackled behind his back before the door is popped, and then would exercise by himself? And so critically important that you specify context as you're looking at or trying to understand what's the likelihood.
Okay, and is there an analogy that you can give the jury about risk assessment that's common to everyday experience?
Well, yes, ma'am. The same 4 factors, the sub-questions that we're looking at here, these are the same ones that are asked by the automobile insurance industry, who are in the commercial business of risk assessment. They're simply looking at a different type of risk. Instead of risk of violence, they're looking at risk of property damage or personal injury. And so they're asking the same questions. What's the probability of what type or severity of accident, at what age driver, in what driving locale? And so we're essentially bringing those same kinds of questions to bear in the risk assessment we're looking at here.
Okay, Doctor, are there different risk assessment techniques that you can use?
Well, yes, ma'am. And these, as reflected on the slide, range from more scientific, more objective, to less scientific. Now, the most objective, most scientific approach is the actuarial or group statistical approach, or the insurance company method. That's where you define the group, you track your experience with that group, and on the basis of that experience, you identify what the probability or the casualty rate is. And so, for example, when my son turned 16 years old, my insurance rates went up $1,000 a year. That's based on their experience with 16-year-old male unmarried drivers. Now, in other words, they've identified the correlates of likelihood of accident and defined the group in that way, 16-year-old male unmarried drivers. They set my premium based on their experience with that group. So I figured that group cost them about $600 on average a piece, and there's $200 for clerical and handling and $200 for profit, and my insurance rate goes up to that extent. And so that's an example of this insurance company method. Now, as we go forward, we'll be defining Eriese in terms of what age is he? What does his education have to do with the likelihood of it? What about being a capital offender, if we define him in that way? What about defining him as a capital offender who's killed a law enforcement officer? And so we will then integrate these research-derived factors that raise or lower the risk. So that's the actuarial method. The second most accurate approach is a past pattern approach, or an animistic approach. And that's the idea that the best predictor of future behavior is past behavior. Now, that's true as long as you have two critically important elements. You have enough behavior to form a pattern, and your context of prediction is sufficiently similar. Enough behavior to form a pattern, and a context of prediction that's sufficiently similar. So, for example, the way that my son at 16 might drive on Friday night when he's out with his friends seems to have no correlation to the way he drives on Sunday morning with me sitting next to him in the front seat. Same kid, same car, fundamentally different contexts. The way the class acts with the substitute teacher seems to have no relationship to the way they act with their regular teacher. Same kids, same classroom, but a fundamentally different context. For that reason, what we'll observe is that violence in the community predicts violence in the open community. It does not predict violence in prison. Violence in prison predicts violence in prison. Critically important to examine context. The third approach is intensive clinical evaluation. That's what you would expect a psychologist to do. To go in and interview somebody, give them some psychological tests, personality tests, and on the basis of that, identify personality characteristics and traits. And from that, project their long-range risk of violence. Now, that approach sounds good, but it is notoriously unreliable in terms of forecasting prison violence, and is likely to distract the person from the factors that really are predictive. Now, some of that is based on, again, on group data, on the frequency of things. So, for example, let's say I identify that an individual is impulsive. And so I say, well, I think because he's impulsive, he's then going to be more likely to commit violence in prison. Now, the problem with that is there's no research that demonstrates that being impulsive is associated with greater violence in prison. And there's a reason for that. Virtually everybody in prison is impulsive. If you weren't impulsive, you wouldn't end up doing this crime that you went to prison on. And so anything that is almost universally present in a given group will fail to predict the rare act. And so it sounds good to take this approach. It simply doesn't work. And then the fourth approach is hypothetical inference. That's where you'd say, well, Dr. Cunningham, I want you to assume that this offender carried out this offense in this way against this victim, and he's had these prior interactions with those sorts of victims before, and here are other things about his life. What do you think of somebody like that and his likelihood of being violent in prison? Well, that's like seeing figures or animals in the stars, where you take a few points of light and you draw a lot of lines. Only you could really make the shape of anything out of those same points of light. And so that approach is completely speculative unless those points of light are anchored to research-driven characteristics. So, for example, if your points of light are, he's age 28, in a murder that involved a law enforcement officer who has this education, who has this family coming to see him, who has this record in confinement, who's been convicted of capital murder, who's facing life without parole. With those points of light, you would get extremely close to the same risk assessment that you would have if you added an interview on it as well. Because the factors, the points of light that help inform this are limited, and they're ones that are available from the records in many cases.
That's my vote.
Yes, ma'am.
I need one up. Oh, I'm sorry.
Members of the jury, thank you all for your attention. We'll go ahead and take our lunch break now. If I can come back at 1:15 p.m. down to your jury assembly room, I want to come get y'all. Please don't discuss the case. Thanks for bearing with us. Thank you, Phil. Please come back at 1:15 p.m. Please be on time. We'll off the record till 1:15.